Hello, and welcome back to Coin Lady channel. The most essential element of Judge Analisa Torres' judgment in the SEC versus Ripple case, in which she determined that XRP is not a security, has been flatly denied. She accomplished this by pointing out that XRP does not meet Howey's criteria for an asset. That's a better approximation of how she put it. Another judge has ruled that the central argument in the SEC versus Ripple case, that XRP is a security because of the way it operates, is without merit. It's intriguing that both Judge Torres and this other judge work in the same district. Therefore, it is difficult for me to understand how a judge could agree with the SEC that an asset is a security simply because of its existence. It baffles me to no end, especially when I consider the work of attorney Louis Cohen, co-author with a few others, I believe, on the ineluctable modality of securities laws, in which he examines every case involving violations of securities laws going back to 1946 and concludes that there has never been an instance in which a violation occurred if, first of all, there wasn't a contract. After looking into the matter further, he came to the conclusion that there has never been an instance in which the asset itself served as the true security. The fact that a judge has ruled otherwise is mind-boggling. The good news is that what Judge Torres said is now the law, therefore it doesn't matter what this judge says. As a result, XRP has been reinstated on all major US trading platforms within hours of the ruling's release. It's so stunning that it defies belief. The speed with which it occurred pleasantly surprised me. However, the judge's decision in a different case will not affect whether or not XRP is secure. That's the encouraging news then. Even so, the whole thing is absurd. What attorneys Jeremy Hogan and John Deaton have stated thus far will be relayed. Based on their comments, I anticipate that Deaton will elaborate further in the near future. But I will tell you the most recent update from him on this. But I'll just state right off the bat that, although this is completely crazy, his outlook is pretty much like mine, like in the end. That's how I would have put it, and it won't change anything anyway. Since I've already explained why XRP is as valuable as gold in prior videos, I won't waste time going over the same ground again. But even if the appeal is successful, Judge Torres can still rule that XRP isn't a security because she considered other weighty elements, something she wasn't required to do. Because if even one criterion isn't met, the transaction in question isn't a security, she only needed to consider the lightest of the conditions in her summary judgment ruling. Not all of them do, as she discovered. Therefore, she must return. That's why I'm not very concerned. But even if it somehow made it to the Supreme Court or some other higher court, I still wouldn't give a damn. It will be of no consequence. The SEC is fighting a losing battle against time. Just so we're clear, I have no legal or financial backing of any type before I go any further into detail and share with you the ludicrous information here. I am not qualified to give you financial or legal counsel. And remember, you should never use anything I say as a reason to buy or sell something. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. A headline from the coin desk, if you will. This topic has been on everyone's lips recently. The judge denied Terraform Labs' move to dismiss the SEC action because of the precedent set by the Ripple ruling. You all remember the Terra Luna crash. It was this event that sent the cryptocurrency market into a tailspin in May of last year. Also related to the guy on your screen right now, DocQ's founder. That's the case with this litigation. This is what the piece says: the United States Securities and Exchange Commission, SEC, filed a lawsuit against stablecoin issuer or Terraform Labs on Monday, and the federal judge who heard the case ruled against the defendants, saying the SEC has adequately shown it has jurisdiction and stated a reasonable argument that Terra USD for short, is fraudulent. Luna may have broken securities law, as indicated by the UST, the Anchor protocol's ticker symbol. Importantly, U.S. District Judge Jed Rakoff of the Southern District of New York also rejected the use of a ruling from fellow Judge Analisa Torres, who recently ruled that Ripple Labs, another defendant against the SEC, did not violate securities law in making XRP available on secondary platforms for retail investors to purchase. In a motion to dismiss, Terraform argued that customers bought ST for functional purposes rather than as an investment when they purchased Luna tokens earlier this year on charges of misleading investors about UST, a stablecoin pegged to the US dollar. Last year, Terraform's lawyers cited a ruling by Judge Torres, who found that while Ripple had broken the law by selling XRP to institutional investors, retail investors had no way of knowing they were buying XRP from Ripple because they purchased the token or intermediary exchanges on intermediate exchanges rather, through Ripple's programmatic sales. It wasn't through Ripple's or programmatic sales, rather, Ripple conducted its own programmatic sales in addition to those on the secondary market. Ripple has no say over what the contents of its token represent, and so it is possible that they will end up on an exchange from where people can buy them on secondary marketplaces. They can't change that. As a result, neither you nor I have ever bought XRP from Ripple, as they have never done so before. Despite the awkward wording, I believe they largely captured the intended meaning. We are still at peace. Check out this comment from Judge Rakoff's order from Monday. This is absolutely Looney Tunes land. I'm relieved that we had pharmacies available because otherwise, everything may have gone horribly wrong and we'd all be doomed. But here's what the judge had to say about it. The defendant's efforts could not, the court ruled, account for any anticipated profits, but here's the remainder of the code. However, he does not differentiate between buyers in any way. Whether or not a reasonable person would view the defendant's actions and statements as evincing a promise of profits based on their efforts in quote is not affected by whether or not the purchaser bought the coins directly from the defendants or instead in a secondary resale transaction. This concludes the Looney Tunes era. That's ridiculous, especially since she was using the SEC's own language, institutional and programmatic sales, to describe something that isn't even. So that's why she talks like that, too. However, she did the right thing by adapting our testing procedures to fit these acquisitions. Therefore, the speculation that XRP itself is a security is baseless. Similar to the Howey case of 1946, when orange groves were involved with orange groves and oranges. If the judge's opinion on the XRP case and the SEC versus Ripple men is representative of his true beliefs, then he should argue that way in the 1946 case too, if he wants to be intellectually consistent. If he is to be consistent, he must contend that it makes no difference whether you buy oranges from the W.J. Howey Court, Howey Co., or from a grocery shop. Any sane person can see that we were putting our faith on W.J. Helico's efforts. The oranges themselves aren't the asset, even if you acquire them in a secondary market like a grocery shop. That's why it's safe. They do not exist. It blows my mind that someone with so much authority and control over other people's lives could have such a blatant disregard for the rule of law. That is just false. In a word, it's vile. The SEC has indicated in the past that it may file an appeal. During the motion to dismiss stage, which is discussed in this article, the allegations made by the SEC must be taken as factual. He pointed out that Terraform had begun a public push to urge individual and institutional investors to purchase USD, and the SEC confirmed as much in its filing. Okay, so what ended up happening in the SEC versus Ripple case? John Deaton claims to have sworn statements from thousands of XRP holders as proof. This demonstrates that most people who buy XRP for the first time had never heard of Ripple. When the judge makes a ruling like this one, it's a what does he mean by this? And he also wrote that a secondary resale wouldn't change whether or not an impartial observer would interpret the defendant's conduct as words. That settles it, then. In any case, he is implying that you are counting on Ripple to do stuff right there, which will increase the value of XRP, even if you don't realize it. The judge's ruling implies, then, that the vast majority of first XRP buyers cannot be considered reasonable. Are you serious? What a ridiculous idea. Holy crap, this is awful. Absolutely ridiculous. Here, therefore, is what Hogan, the attorney, had to say. The Terra judge is unaware that many XRP buyers have submitted David affidavits claiming they had no idea who or what Ripple was when they made their purchases. Because of this, evidence is crucial. And at this point, there is no proof. So, listen, I get that the judge made his ruling without any hard evidence to back it up. That, however, is his starting position, and the fact that it runs counter to established judicial practice is extremely worrisome. The good news is that, as I mentioned at the opening, this won't affect the outcome of the SEC versus Ripple lawsuit. The final say on whether or not we'll be okay rests with Judge Torres. In spite of this, the very act of having this debate is insulting, because, well, what? I have invested in roughly 30 different digital currencies. If more people shared the judge's flawed worldview, my business would suffer and my personal wealth would diminish if those in authority got their way. If they did, it would seriously damage my finances. That's encrypted language for anyone listening. Here is what Deaton, the lawyer, had to say about it. A lot of people want to know why the Terra Luna judges disapproved of your work and how it differs from the Torres verdict. While I was out of town, I missed the ruling. A judge from the same district as Judge Torres could find it difficult to publicly disagree with him, as I suggested earlier. It would appear that this judge was not under any pressure. This is inherent in the legal process. After I hear the verdict, I'll have more to say. At summary judgment, however, Judge Torres was using the Howey standards to weigh incontestable evidence. Our efforts helped to sway the judge's decision in Ripple, where the SEC's expert witnesses' judgment on retail investors was at issue. We provided the SEC with thousands of affidavits from XRP holders who claimed to have acquired XRP without knowing about Ripple and for reasons other than investment, and they found no indication that retail investors were depending on Ripple. The judge's decision does not shake my faith in the original Torres verdict. You've entered the world of litigation. Exactly right. That's why I can't wait to hear what more lawyer Deaton has to say. And that's something I'm sure the next video will address. When he finally says it. My guess is that he'll start a Twitter thread about it because, oh, right, economics is what it's called these days. So, as soon as we find out, I'll gladly include the thoughts and opinions of others in this discussion. There will be much more discussion on this topic. And again, as far as my understanding goes, this would have zero effect on us as XRP holders. But isn't that really ridiculous, what they're saying? Should you trust a judge? That's where we're at now. If you want to disagree with this, you'll need to accept that the item itself serves as the security. This judge claimed it was obviously ridiculous. No, I don't give out financial advice. Nothing I say should influence any purchases you make for yourself. Please like and subscribe my channel. See you later, bye.